You own a property, you want to lease out to someone, and you get all the documentation prepared, instructions to your lawyer, or your agent puts instructions to your lawyer, and your lawyer comes up with a recommendation that you should insert a demolition clause. The question is, should you or shouldn't you? Now, not a simple answer to that question. There are advantages and disadvantages. Obviously, if it's ready to develop in 12 months' time, you've got the DA approval, you've got all the contractors ready to go, and you've only got a 1 year window and you want to give it to someone for 1 year for a reasonable rent, then it may be worthwhile. But how does it work in a practical situation? Now, I'll go through how it's advantage and when you should use it. But firstly, I'll give you a definition of what demolition clause is. Demolition clauses are contractual provisions that permit landlords to terminate commercial leases prior to the natural expiration date when the landlord intends to demolish, substantially renovate, or redevelop the property. That could be a bit ambiguous. The scope of these clauses extends far beyond actual demolition. Often encompasses relative minor renovations that provide landlords with broad termination rights. So when you do put this forward, you've got the other lawyer on the other side commenting, thinking about their client situation. The legal framework varies significantly across jurisdictions, but most demolition clauses require landlords to provide between 6 to 12 months written notice and demonstrate a genuine proposal for redevelopment. However, the definition of substantial renovation remains deliberately allowing landlords considerable flexibility in exercising these rights. So it's very hard to define. Commercial demolition clauses represent one of the most controversial and financial impactful provisions in modern commercial real estate, creating dramatic wealth building opportunities for property investors while simultaneously destroying the livelihoods of smaller business owners. The legal right, these clauses can give the landlord legal right to terminate leases early for redevelopment purposes, fundamentally altering the risk-reward equation for all parties involved in commercial leasing arrangements. Now, you've got to think about the situation. Now, you look at it from the other side, the business owner or the lessee. They're going to spend a bit of money fitting out a premises or buying an existing business, knowing they get a return on their investment, their initial cost to set it up or buy the business, and make a profit as well. Now, for example, if they're buying a business on a 3-to-1 profit ratio, so that they've got to recover their buying price in 3 years. And if you've got a demolition clause for 1 year, it doesn't seem like a good idea. How do you get around it? The way I used to get around these demolition clauses is you can have a compensation scheme. So you're compensating a certain amount of money if you terminate them after 1 year, 2 years, 3 years, whatever the term is. And obviously, towards the end of their term, it's a smaller amount. That seems to be palatable for most people. But the other thing is that a lot of landlords think that even though it's got a demolition clause in the lease, they should still get the same market rental. In practice, it doesn't really hold true. The rental charge with no compensation provisions is sometimes around half the market rental. So that could be an advantage to both parties. The thing is that when you look at inserting demolition clause, look at the practicality of the whole situation. Look at the surrounding area you're in. Are there any buildings of larger FSR than you are? Are there new approvals or rezonings for higher floor space ratio, redevelopment in the area? What's the demand for space there? And more importantly, if you've got several tenants in your building, do the other tenancies have demolition clauses? Is there a period in the future where every tenant can be terminated? Now, if you've got 4 tenants and there's one tenant got 5 years to go with no demolition clause, and you're looking at putting a new tenant on a demolition clause, it doesn't really make sense, because you can't do anything for 5 years anyway, unless you compensate them, and you don't know what the compensation is going to be. Maybe discuss it with the other tenant, whether they want to leave after a certain period of time. And if they think that you're going to do something with the building, they may decide to leave anyway when the other leases expire. And what happens if you don't decide you don't want to redevelop the building, or you want to sell the building, someone else wants to buy it as an investment, doesn't want to do anything with it? You could have problems. So think about the whole situation. What can you realistically do? Is the redevelopment, refurbishment going to pay off? Basically boils down to return on investment. So when you've got a demolition clause, get a property specialist to work with you to ensure your leases are all in sync and you've got a plan for the future. So if you want to redevelop in a certain period of time, place will be vacated so you can do the work.